Okay, thanks everybody. We're going to get started. We have a great group of registrants. We are live and webinar, so we have about 100 of you in attendance today. And we welcome you to the Dorsey and Whitney Food and Agribusiness Industry Group webinar and live program on an exploration of the commercial use of drones in agribusiness. My name's Bridget Hayden. I'm a partner at Dorsey and Whitney and a member of the Patent Practice Group and also the co-chair of the firm's Food and Agribusiness Industry Group. Our industry group includes over 240 attorneys across the firm's different practice areas and offices that have expertise in the food and/or agriculture space. Dorsey's speakers today represent just a small sliver of the expertise we have in our industry group. Jamie Nafziger is a partner in our trademark group, and Thad Lightfoot is a partner in our regulatory affairs group. Drones, or UAVs, are not new. They've been used in military applications for many years, but today they're used in areas such as precision agriculture, evaluating air emissions, inspecting pipelines and transmission lines, and conducting insurance inspections and building inspections, to name a few. In view of these commercial applications, our clients are facing legal issues more frequently. We have a great program for you today that will cover some of the larger issues associated with the use of UAVs in commerce and is broken into 3 sessions. The first session will be on Drones 101 with Thad Lightfoot and Chris Draper. Our second session will be on privacy and intellectual property in precision agriculture and in infrastructure, and will be provided by Jamie Nafziger. And our third session will be a business panel discussion with some of our experts, including Eric Typala, Aaron Lessig, and Eileen Lockhart. The first and the third sessions will last about 60 minutes, and the second session will last about 45 minutes with breaks between sessions. But before we get started, for those attending live, please sign the green sign-in sheets to obtain CLE credit. If you're joining via webinar, please print off and sign the sheet that was provided to you with the seminar materials. The instructions for completing the form are included on the form itself. For New York CLE credit, we will be providing you with 3 different CLE codes, 1 for each of today's sessions, so stay tuned. Also, for those attending live, please note that we have included question cards on each of the tables. If you have a question, please fill these out anytime during the sessions, and Jane will come by periodically and pick them up and provide them to the speakers. For webinar participants, please send your questions to www.dorseyu.com. That's www.dorseyu.com. And if we don't get to everybody's questions during the program, someone will be back with you as soon as possible. Moving to the first session, Drones 101, adding value to agribusiness and other enterprises. Our speakers will provide an overview of the current and future use of drones in agriculture and infrastructure and regulatory considerations. Thad Lightfoot and Chris Draper will be your speakers. Thad is a partner in the firm's regulatory affairs group and is a former trial attorney with the Environment Division of the United States Department of Justice. In nearly 3 decades of practicing environmental law, he has represented corporate clients in a variety of sectors, including the agriculture, aerospace, mining, forest products, paper, steel, manufacturing, electronics, pharmaceutical, real estate development, and ethanol industries. In addition, Thad has represented the operator of Minneapolis-St. Paul International Airport for 20 years and has recently advised clients on FAA exemptions for commercial use of unmanned aircraft. Dr. Chris Draper is the director at Mead. He has over 15 years of experience designing, developing, and analyzing unconventional electromechanical systems for the aerospace, automotive, petrochemical, and facilities industries. In the aerospace industry, Chris helps develop operational standards, regulations, and policies governing space launch and drone operations. These efforts include his creation of the time lag analysis model for predicting piloted reusable launch vehicle flight dispersions, the probabilistic aircraft vulnerability model for modeling aircraft risk relative to impacting debris, the bivariate learning model for predicting reliability growth in non-Bernoulli samples, the USSE similarity model for stochastic assessment of unproven vehicle success rates, and the Draper-Santos airspace model for integrating unproven vehicles in national airspace systems. He received a Bachelor of Science in Mechanical Engineering from the University of California at Berkeley and a Doctor of Philosophy from the University of Glasgow in Scotland. Take it away, Thad and Chris.
Well, thanks very much, Bridget, and welcome to everyone this morning. I wanted to call this session Game of Drones, but couldn't get the copyright to the Game of Thrones theme, and besides, Chris Draper said, don't do that. So I got to make the joke, but not name the session Game of Drones. All right, so why are we here? It's all about FAA regulation, or Federal Aviation Administration regulation, of the national airspace system. And as you see in the slide, aircraft operations in the national airspace system require a certified pilot, a registered aircraft, a licensed pilot, and operational approval. Is a UAV an unmanned aircraft vehicle or an unmanned aircraft system, UAS, an aircraft? Yes, in fact, it is. So if it is operating in the national airspace system, which FAA deems to be everything from about an inch above your lawn to 60,000 feet, then there's going to be FAA regulation. And if that's the case, you need a licensed pilot. You need either a civil or commercial pilot's license, along with a medical certificate, and operational approval of the aircraft. And the aircraft has to be certified and registered with a tail number and with an airworthiness certification. So FAA regulates in the national airspace system even at very low altitudes. And this next slide is a diagram of the national airspace system. You can see that it goes all the way up to 60,000 feet, Class A through Class G. Class F actually isn't used in the United States. Why they skipped it, I have no idea. But most of the time when we're talking about UAVs, we're talking about operations in Class G airspace, which is typically between 700 and 1,200 feet above ground, or AGL, above ground level. But the reason I put this slide up here, and you'll see it again when we talk a bit about the Part 107 regulations that that went into effect 2 days ago. They're important because the airspace differs on class based upon location to an airport. And you see on this slide the funnels, if you can see them, and that little crosshatch next to the funnels on the slide, that indicates an airport, and it indicates an airport that is controlled by an air traffic control tower. And so Class G aircraft, or Class D airspace, is near an airport up to about 2,500 feet. Class C airspace is up to 4,000 feet in key airports, and usually about 5 nautical miles from that airport too. And Class B airspace is regulated more heavily, typically near and above the busiest airports. Class A airspace from 18,000 feet to 60,000 feet is the most regulated of the airspace in the national airspace system. Well, first thing we can do in our discussion here is eliminate hobby aircraft. I call this guys and drones, but I guess this photograph. But all of the aircraft that are shown here are hobby aircraft or model aircraft, and they are exempt from FAA regulation, largely exempt from FAA regulation. As of February 2016, you needed to put a tail number on your hobby aircraft if it was over a half a pound and up to 55 pounds, and then if it was over 55 pounds, I'm not sure that's a hobby aircraft, but it required a different type of registration. FAA defines hobby relatively narrowly. It's outside of one's regular occupation. They define commercial operations, which is what we're talking about here today, much more broadly. So before the new FAA regulations that went into place 2 days ago, 14 CFR Part 107, which we'll talk about a fair amount here, the only way you could get a waiver from requiring a airworthiness certification for a UAV was through the Section 333 waiver process, which Congress established in the FAA Modernization and Reform Act of 2012. And it's a process that still exists. It's a process that, as we'll discuss when we talk about Part 107 and waivers, it's going to still exist, specifically if you want to fly a UAV that is 55 pounds or over. But it is a relatively complicated process. First, you have to identify a pilot, and that is someone that holds a pilot's license, a Part 61 pilot's license, and a medical certification under Part 67. In other words, a manned aircraft pilot. Second, you need to submit an application for the waiver process. And those applications talked about the scope of the UAV operations, what UAV you would be doing, what UAV you would be using, what you would be doing, and where you would be flying it, and the like. They were, as I said, they were complex. They're multi-page applications. Often they would involve some legal assistance. I know that some firms were providing flat fees to file those applications for you for $5,000 or $7,000, so not inexpensive, certainly. And the other key here was that the Section 333 exemption has to be within the public interest, not within your interest in terms of flying a UAV, but within the public interest. And then after you file that application, you got to wait. And there is a 90-day public comment period on those applications, so at a minimum, you're waiting 90 days to fly unless FAA expedited the application, and typically you would wait often much longer. By the middle of this month or so, nevertheless, there were about 5,600 or so Section 333 exemptions that FAA had issued. Then you needed a registration number for the tail of your UAV, and then you got to fly. But only then did you get to fly. And you also, because you had a pilot, you needed a notice to airmen, you needed documents, you needed to take a look, you needed that pilot to do pre-flight checks of the drone. Most pilots who were flying drones under Section 333 exemptions kept logbooks. They weren't required, but they're often necessary to prove the kind of information that you needed to provide FAA. As I said, wait, yes. Now FAA, if you hop on FAA's website now on Section 333, you will find that they are warning you that because of the high volume of petitions received, they're experiencing delays in processing. Again, something to remember if you need a Section 333 exemption. Well, what if you don't need what's the harm in just flying without a Section 333 exemption? Well, there's FAA enforcement, and the most notorious case came out last October or November, the Skypan International case. Skypan undertook about 65 drone flights or UAV flights, and these are actual Skypan drones, so they're heavy. They're not like that white one on the back table there. These are large-scale drones. 65 flights in Class B airspace, by the way, so near the country's busiest airports, over individuals, over people, over populated areas, without a Section 333 exemption. Not a very smart thing to do by our friends at Skypan. So FAA proposed a $1.9 million, that's right, $1.9 million fine for those flights. That's why you don't fly without a Section 333 exemption. That's still pending. Whether it will actually end up to be that much, I don't know, but the number in and of itself is worth contemplating. A little closer to home, and more recently in June of 2016, FAA fined an Eden Prairie man $55,000 for 11 unauthorized drone flights without a Section 333 exemption. Why? Well, he had a friend who was very upset about the Minnesota dentist who killed the lion Cecil on safari, which got national news. And so a number of friends of this individual's got together, and they were going to do a little protest. They kind of formed a lion on the ground, and then this fellow who's in trouble with the FAA flew his drone over the lion, took some pictures, gave them to his friend, didn't sell them, gave them to his friend. The FAA said, no, that's commercial use of a drone without a Section 333 exemption, and therefore you need to pay us $55,000. Again, that fine is still pending, but that's why you don't fly without proper authorization. Well, the real game changer, I think, and one that I'll spend most of my time talking about, and one that you'll hear a lot about in this program today, are the FAA's new regulations that went final in June of 2016, published in the Federal Register in June of 2016, and went into effect 2 days ago on August 29th. Those are the regulations that are codified in Part 107 in Title 14 of the Code of Federal Regulations. And this, unlike Section 333, unlike the statutory process, this is not an exemption process. If you meet the requirements under Part 107 and you get a tail number, you can fly, period. You don't need to apply to FAA. You don't need to apply for an exemption. You just meet the exemption. You meet those requirements and fly. Most important requirement, perhaps, in Section 107 is the weight of the UAV. It has to be less than 55 pounds at takeoff with all attachments. That is gross weight. Now, you can hang a camera on a UAV under Part 107. You can hang any other accessories on your UAV under Part 107, so long as it doesn't impair the UAV's ability to fly. But it can't be more than 54.99 pounds gross weight at takeoff. Second important operational limitation is that it has to be, for Part 107, in visual line of sight. Part 107 creates a new category of pilot, a remote pilot in command, which is a person, and we'll talk about the qualifications here in a minute, but a person who's operating the controls and is qualified to operate the controls of that UAV, and it's got to be within a line of sight. However, having said that, we'll talk about the Part 107 waiver process here in a moment. FAA has already issued 2 beyond line of sight waivers under Part 107 to a couple of companies. More on that in a moment. Minimum weather conditions. By the way, in terms of visual line of sight, you have to be able to see the drone. The pilot in charge has to be able to see the drone with only the use of corrective lenses, if you're like me and wear glasses, not with a telescope or anything of that nature. It's got to be able to be seen by corrective lenses within the line of sight. And typically that's, depending on the size of the drone, that's 2.5, 3 miles at most for a drone that's under 55 pounds. Part 107 also requires 3 miles of visibility from the control station, and there are certain limits with respect to you can't be within 500 feet of a cloud and that sort of thing. Another key component, daylight operations, or really daylight and twilight, meaning 30 minutes before sunrise and 30 minutes after sunset. Although having said that, there are already a number of waivers that FAA has granted just in the last 2 days on operations at night. And then, actually 76 already. And then heightened speed, 400 feet high, except if you're above a structure, then you have to be within 400 feet of the structure. More on that in a minute. And maximum ground speed of 100 miles an hour, or 87 knots. Okay, so where can you fly? Back to our national airspace diagram again. If you are in Class G airspace under Part 107, that is, again, usually below 700 feet or below 700 to 1,200 feet, depending upon how close you are to an airport. and uncontrolled, then you can fly in that area under Part 107 without any advanced air traffic control or FAA approval. If you are in other airspaces, if you're near an airport, then you're going to need FAA advanced air traffic control approval from FAA before you can fly. And as promised, FAA has created a waiver process and an airspace authorization form. It's on their website. You just go in there, identify how close you are to an airport, fill out the form, and then eventually you'll get FAA or air traffic control approval. Unclear as to how long it will take. We don't really know yet, but that's the way you would do it if you are near an airport. Note that air traffic control will consider these operations. They'll consider potential effect on traffic flow and other operational issues that could affect safety. And if they cannot be mitigated, air traffic control will not let you fly. So this is not a guarantee by any stretch of the imagination. And I can tell you, I was at the Metropolitan Airports Commission last week on a different matter. And they are very concerned, as many airport operators are very concerned, about drones being flown near airports. And this sign, which you see on the slide, was in one of their conference rooms. No drones were flying in the conference room, but they're getting ready to post them all over the airport. And you see it's got the International No sign there with, the Airports Commission prohibits drone operations on its properties except if FAA allows, and that's the other language. So they're very concerned about that. In any event, Part 107 says you cannot operate in the vicinity of an airport in a manner that interferes with airport operations. Okay, so I said that Part 107 creates this remote pilot in command, which is new, and that is correct. Again, unlike Section 333 exemptions, to fly a drone under Part 107, you don't need a commercial or a civil pilot's license. To qualify for the remote pilot in command certificate, a person has to demonstrate aeronautical knowledge by passing an initial test at an FAA testing center and then getting retested every 2 years. Has to be vetted by TSA and has to be at least 16 years old. Now, when these rules came out in June, I saw a few people quoted in the press as saying, oh yeah, everybody will be able to fly these. Not everybody will be able to fly these, and if you take a look at the aeronautical tests, or at least what's likely to be in the aeronautical test, without some training, you are not going to be able to pass the test. I'm sorry, you just won't. Now, there are a number of places that are popping up online, not surprisingly, that will train you to take this test, and if you fail it, you can take it again in 2 weeks. Of course, you pay another $150. For the privilege to do that. But don't think that you're going to be able to grab your 16-year-old son and send him off and have him pass the test after he just got his driver's license. That's unlikely to happen. If you hold a Part 61 pilot's license right now, you still need this certification, but you can get it automatically if you apply to take the test. So the moment you apply for the certificate, you get a temporary remote pilot in command before you even pass the test. You get a temporary certificate. And right now, at least, foreign certified UAS or UAV pilots still have to pass this test. You can't rely upon the foreign certification. The other thing that it may seem obvious, but Part 107 requires that you speak right and understand English, which makes some sense. Okay, so other considerations under Part 107. There are some additional operational limits. You can't operate these under 107 from moving aircraft. You can't carry hazardous materials. And by the way, that's the long U.S. Department of Transportation hazardous materials list, the one that has tens of thousands of substances on it, including pesticides. No operations over persons other than the pilot in command or the person who's actually operating the controls next to the pilot in command and a visual observer if you're using one on the ground. So unless those people are in buildings that are protected by roofs. So the concern FAA has is that if the drone falls, they don't want it falling on people. So again, when I was when these rules came out in June, a lot of people were saying, oh, well, everybody on a farm will be a person that you could fly over. And that is not the case. The people have to be protected unless you get a waiver. So if you're checking a pipeline or a stack or something, you can't fly it over your employees. They have to be out of the way. Now, many of the Part 107 operational requirements that we've discussed here this morning are subject to a waiver. And the waiver process is already set up. It's on FAA's website. You go on, you identify the operational requirement that you'd like to see waived and make an application to FAA. Daylight operation is a key one that is waivable. And in fact, of the 80 or so waivers that FAA has already granted in the first couple of days of Part 107, most of them are for daylight or for evening or nighttime operations. Now, the UAV is going to have to be lighted if you're going to operate it at night, and there may be some other requirements, but that is certainly waivable. Visual line of sight is waivable, and we've seen now 2 waivers for beyond visual line of sight under Part 107. More are likely to be involved or coming soon. Operations over people. So again, if you can show safety and protection over individuals, they don't necessarily have to be in a building with a roof, but you've got to file a waiver under Part 107 first. The waiver process seems to be, one of the concerns that we had going into this was how long would it take to get a Part 107 waiver? The waiver process seems to be going pretty quickly. Who knows? Now that these regulations are actually effective, I don't know that will continue, but it does seem to be moving quickly. There are a few requirements that are not subject to waiver under Part 107. The biggest one, the most important one, is weight. If you want to fly a UAV that is 55 pounds or more gross weight at takeoff, the FAA cannot, by rule, waive that your ability to do that under Part 107. That's going to require, still back to our friend Section 333, that's going to require a Section 333 exemption, which means you're going to need a pilot and to meet the other Section 333 requirements. I've also seen some presentations and some people saying, well, Section 333, Part 107 replaces Section 333. It doesn't. It does not replace it. For anything that cannot be waived under Section 107, you're going to be in the parts, or under Part 107, you're going to be in the Section 333 process. For anything that FAA deems that might be waivable, but your application didn't prove that it was safe, you're going to be dealing with the Section 133 exemption as opposed to Part 107. And obviously, carrying hazardous materials isn't waivable under Part 107, and I think you're going to have a tough time getting an authorization to do that under Section 333 as well. Okay, so what might this look like in terms of ag operations under Part 107? As I said, I think that this Part 107 really opens up the use of UAVs for precision agriculture in a way that was difficult under Section 333 and more complicated under Section 333, and was illegal if you didn't have a Section 333 exemption. Let's say you you needed to photograph or you wanted to monitor crops, even on a large agricultural farm, and even with a line of sight visibility requirement. Well, as I said, line of sight visibility requirement for fixed-wing aircraft, fixed-wing UAVs, about 2.5, maybe 3 miles if you're not unlike me and you have particularly good eyesight. What if you have a farm that's larger than that, or you need to cover an area that is larger than that? Well, you could fly the UAV back and get in a car and drive and do it and drive in the next spot and fly the UAV. Or Part 107 allows remote pilots in control to essentially transfer or trade off control of a UAV to transfer from one pilot to another. So if one remote pilot in charge has visual contact with a UAV but is losing it and is in communication with another remote pilot in charge, he or she can let that person know, I'm losing contact with the UAV, you need to pick it up. The other person can radio back and say, okay, I've got it. And that's perfectly authorized, that's perfectly acceptable under Part 107, so long as a pilot in charge on the ground, one, by the way, it's one pilot per UAV, not multiple pilots, although that's waivable too, but one pilot per UAV at a time, so long as that trade-off happens in real-time communication, that's allowed under Part 107. A couple of caveats with respect to agricultural uses in Part 107. Another, and I don't want to throw too many Code of Federal Regulations sections at you, but there is a different code of the of the CFR, 14 CFR 137, that regulates agricultural aircraft operations. And without getting into all the gory details, an agricultural aircraft operation is essentially dispensing anything from an aircraft, even water. So if you are dispensing, or you want to dispense something from a UAV, then you're going to need to establish, then that is an agricultural aircraft operation. You're going to need a pilot, you're going to need a certified pilot, and you're going to need an aircraft with an airworthiness certificate that is designed to deal with, to provide agricultural aircraft operations. Or you're going to need to go into Section 333, and even then you're going to have to deal with this issue of agricultural aircraft operations. So again, if you're thinking about using it to spray fields, that's not going to work. If you're thinking about using it for irrigation, that's unlikely to work under Part 107. The real focus, I think, is crop monitoring and photography. Okay, so what about infrastructure? Well, here we've got a couple of, actually these are cooling towers, but they could be emission stacks. And it's back to this question of 400 feet. You can fly under Part 107 at 400 feet or 400 feet above a structure. So or 400 feet within the structure. So as long as a UAV is within 400 feet of the top of a stack or the side of a stack, it can be flown under Part 107. Now remember, there are cloud requirements and there are other requirements, and you can't fly over people. And remember as well that if you've got a 400-foot stack and you're 400 feet above that, in many cases you're outside of Part G airspace. And so you may need air traffic control approval before you do that sort of work. But it's not just 400 feet above ground level, it's 400 feet above a structure. How about pipelines? Well, again, with this trade-off in terms of transferring control from one remote pilot in charge to another, in theory, you could check pipelines relatively easily under Part 107 with the other issues. One last point on infrastructure. Last month, the President signed the FAA Extension, Safety, and Security Act of 2016. It amends the FAA Modernization Act of 2012, which created the Section 333 exemption. And there are a couple of interesting provisions in it for infrastructure. The first is by mid-October, FAA is required to issue guidance that would allow it to, that would explain how it could expedite Section 333 exemptions for civil or public operations in response to a catastrophe. And so the idea is, could you use UAVs to facilitate an emergency response, such as firefighting or search and seizure, to identify and assist in repair of utilities and other infrastructure? And the answer is yes. Right now, you'd probably require Section 333 exemption. FAA is now working on guidance that would allow it, and under Congress's direction, that would allow it to expedite those types of exemptions. The second thing that the extension, the 2016 extension does, is that it establishes a process to allow to allow companies or persons that own critical infrastructure to petition FAA to restrict UAV operations near that critical infrastructure. Why? Because you want to make sure that you don't want to protect that critical infrastructure. And right now, there's no process to do that. Interestingly enough, the statute defines critical infrastructure as things you would expect: energy production and transmission facilities, oil refineries and chemical factories, and other locations that warrant restrictions. But it also specifically lists amusement parks, which I thought was an interesting, I guess someone was concerned about that being a critical structure. But I suppose if you're concerned about some sort of terrorist attack, that makes sense. So that's, amusement parks are there as well. And then the third provision that regarding infrastructure in the statute is that allows and really encourages FAA to, under the Section Part 333 process, look to issues regarding visual line of sight or flights during non-daylight hours to conduct surveys and compliance requirements, also operation and maintenance issues for, again, critical infrastructure such as oil and gas production, pipelines, and the like. All right, so one of the interesting things that arises in this question of say, using a UAV to evaluate a pipeline is, what about easements? You've got an easement for the pipeline, but does the easement have to specifically refer? Does the easement refer to the air? Does it have to specifically refer to a UAV? Or if you're flying under Part 107, do you need to even worry about those issues? I think you need to worry about them still, but this brings us to the question of state law and preemption. Just in general, Congress vests FAA with the authority to regulate airspace. So local and state laws that regulate the operation of aircraft or aircraft equipment or training are preempted by federal law, and that's pretty clear. But the question is, what about local? So if the state of Minnesota, for example, decided that in addition to the test, it was going to have another requirement for a remote pilot in command, that's likely to be preempted because that's a regulation of the operation or training with respect to UAV. But local land use is different, so anytime and not preempted. So if you have zoning issues, privacy, trespass, any land ownership issues, law enforcement issues, those rules are unlikely to be preempted. And in fact, if you look at most of the federal or most of the state statutes dealing with UAVs and regulating UAVs, they tend to be on the local law enforcement issue, as they are in Iowa. For example, in Iowa, you can't use UAV evidence in a criminal or civil proceeding unless you have a warrant first. Or you can't use UAVs to enforce traffic laws. In Minnesota, there were a lot of similar statutes or similar legislation considered by the legislature in the last couple of years. I'm told that there will be more, but nothing has quite passed yet. But in general, the rules that you see at the state level tend to be local land use or local law enforcement uses, and those are unlikely to be preempted. So at least with Section 107, we can keep calm and carry on flying. And that's my presentation. I've got a couple of questions here. So one is, for large companies with different uses, can you submit one waiver request for the entire company, or must you submit a waiver request for each use? I think you could submit a waiver request for the entire company, but you would have to detail the uses. And you would also likely detail, if the facilities are in different places, exactly where those facilities are. That's the key. I mean, you've got to articulate the operations enough to give FAA the information that it can use to make a determination. Can you talk about the person responsible for the waiver request on the FAA form site? I don't know. That's not specifically discussed, at least that I saw in the Part 107 regulations. It might be defined. I don't remember off the top of my head now. I mean, typically, if you are it's a lot like other certifications or other responsible officers or persons. The government wants someone in an official capacity who can represent the company or who can represent the applicant, and I think that's what the responsible person, the person who is actually signing the waiver, the person who is responsible for the waiver, I think that's what FAA is likely to look for at that on the website. And ultimately in processing the waiver. And with that, that's my presentation. I'll turn it over to Chris. Thank you.
Hello. As a sort of recovering reg head, I guess part of the issue here is I won't be on the regulatory side as much as my goal here is to offer really sort of perspective and prediction of what we're looking at as far as the general sense of where we're going as far as the FAA based on what we're doing right now and where we think things are going. As a quick disclaimer, while I do work for the FAA, I don't represent the FAA. These are all my own opinions and things like that, so please don't go and say, hey, Chris said something. You know, who knows what they'll say to that, but hopefully what it's going to do is they'll tell you it's not official either way. Sometimes I get into issues that may be down in the weeds. Please use the standard technique of just hopping on your phone, and that way I'll know that I've gone a little too far, and then we'll figure out how to pull back from that. The fundamental issue we need to really sort of think about when we're thinking about the strategy of how we actually deal with these things and how when we come up with solutions that go off into the future and help not just what's in front of us now, but what could be in front of us, is really sort of think about what are the issues involved with drone regulation and the strategy of drone regulation. When we think about drones right now, one of the issues we have to be really conscious of, it's easy for us to think that the public just doesn't get this thing when we're actually in the industry and thinking about the applications, thinking about precision ag. It's hard to forget that the vast majority of individuals sort of think of drones as that peeping Tom thing that like sort of runs around my yard and I need to somehow like smack that thing out of the air, right? That's how the bulk of society right now is sort of thinking about these drones, and that's sort of part of our challenge is how do we start separating those issues, right? Because the issue isn't necessarily that, these aren't wrong, right? We have plenty of individuals using these drones for the purpose of violating things that are going to be. You were never allowed to actually just hop the fence and jump in your neighbor's house and take pictures. You were then never allowed to actually go and then send those pictures over the airwaves to someone else, right? But those items are someone else's issue, right? We've got DOJ, FCC, we've got all kinds of other areas that deal with those issues. And so really what it gets down to, what are the issues of relevance to us? And while the issue that primarily we're looking at is precision agriculture, making sure these things are flying safely, that we're able to deliver life-saving items, life-saving types of materials. I mean, one can debate whether or not Tide on Amazon, Express is life-saving or not. Depends on how your clothes are doing, however. Or theoretically, as we go into the future, whether or not we're delivering things such as fertilizers, which we're getting to right now, which is, right now this is still a 137 application. The area that the FAA is concerned with, that is relevant, that we need to make sure we are still conscious of, is not the peeping Tom issue, but that this was also fertilizer, right? This was a Ryder truck of fertilizer. The same thing flying through the Central Valley of California, when parked, did this. And the only reason that building's not gone, ironically, is that they parked the truck the wrong angle. If you had parked that truck 90 degrees differently, the building's gone. This is also an accessory that can be added to a drone, right? This is not an FAA issue, but this is a real issue in the drone space in general, and it gets to what are we actually needing to deal with. Now, does everything need to be dealing with this? This is illegal in a number of areas. This is something that we need to be conscious of for other reasons. When we're talking about the FAA and those issues, we need to be careful to understand what are the issues that are relevant. Gets into what is actually why am I up here? I'm not a lawyer. I've known plenty and hang around them from time to time. However, I'm not a lawyer. What my issue is and where my expertise is actually how do we mathematically prove what you're doing safe is safe? When you're getting to your Part 333s, if we want to go over the horizon, how do we make that determination? So far, right, we've identified, and I'm sorry, I didn't know the exact numbers, but for Senate 76 as reported, have already been approved, and we're saying, how are they doing this? Like, boy, unofficial perspective, we don't really fully know yet, right? That's where when you're looking at what we do, my history is on the commercial space side. When you're looking at the commercial space side, and we start bringing those things over into the actual aircraft side, it's going to be far more important to start identifying how do we actually prove this is safe. That's why I'm up here. That's what we're talking about, and that's what the bulk of what we're looking at is first off, what is a drone, if we're going to untangle this stuff, right? What is a drone to actually get in the part, what's really relevant, to be fair, is what's RC versus drone. One characteristic is money. That's our fundamental distinguisher. But a drone in general is a transportation method. In some situations, this transportation method, whether it carries a camera, whether it carries tide, whether it carries anything else, can be more economical, it can be a rational option for you for places that are inaccessible, etc. But it's a transportation method, nothing more. It's not magic. This thing isn't a flying carpet that we're like granting wishes from. It's a transportation method. And certain business environments make a heck of a lot of sense, and others, it's just a toy, right? So we've got to be very, very careful of what we're actually looking at here. The next thing that's very important is now we've got a transportation method that goes through the air, is rightly identified. We're under the FAA's purview, right? Well, FAA is dealing with two things: enabling innovation while ensuring safety, right? That's sort of like telling your kid, we can reward you any way you want, you just can't have cookies, right? I mean, there's a range of issues here we need to actually be conscious of. The FAA has to deal with that contradiction in some cases on a daily basis. So what we're talking about right now is we want to allow for your tide to get there within 3 minutes or whatever it is, right? The thing we have to be conscious of is that when you look at these vehicles, right, and the one in the back, I was at the Advisory Regulatory Committee, and one group was showing this model that they'd done, right? And obviously with mathematics, being a PhD with modeling background, right, you sort of realize there's two ways to look at that. One is we can solve any problem with modeling. The other is we can make any answer we want with modeling. Bit of a problem. They were showing this example where they're dropping that drone back there on someone's head and saying, look, see, it's not that big a deal. Granted, it was a mathematically rendered head, and as you look at that, as you're sitting in the room, you're like, that looks like a great drinking game to do second, right? But the fact is, these things actually have relevant risk, right? Magic number is 11. So as you're thinking through the magic number on these things, 11. 11 is the number of foot-pounds of the government, and I say the government as far as the FAA, when FAA regulations, which are Air Force regulations and NASA regulations too, the magic number is 11. If you transfer 11 foot-pounds to an individual, you have to expect they will be a casualty. Casualty is defined as you're in the hospital at least 24 hours. Again, I can do the reg thing, right? I know a few pieces, but the big issue is 11's our big picture number. Now, what's 11 mean in real world, right? Because 11's easy to say theoretically. Let's start looking at the one on the back there, right? We're looking at a 4-pound item, right? Your casualty velocity is a little over 10 miles per hour, right? That puts you in the hospital. It falls without any restriction at 35, right? If you're under it, it's falling full bore, you're going to the hospital, right? Now, if we look at something, sorry if I sometimes get these back, we're looking at something that sort of pushes the boundary of what's actually acceptable, right? We're sitting up in the high 40s, right? So if your max limit of what you're allowed within the regulation is falling out of the sky at 2.5 miles an hour, that hits you, right? Anyone lift weights? No one in here? A few of you look like you've lifted weights before. Okay, so you're kidding me if you don't. Are you guys on your phone again? Come on, like really? None of you have lifted weights. You ever seen a 45-pound plate in the gym? Right? It's a 45-pound plate. Now, think about this for a quick second. So, if that thing is traveling at 15 feet per second, right, it means it's coming from the back of your car to the front of your car, right, in 1 second, 15 feet per second, and that thing's hitting you. Does that look comfortable? You will go to the hospital, right? You're going, right? 2.5 miles per hour is what your actual casualty threshold is on the largest acceptable weight category currently within this new 107, right? Remember, this thing falls out of the sky. Again, it's something a little in excess of 2.5 miles per hour, right? And I think that's a generous number right there, right? That's generous on the slow side of what that thing's going to fall at, right? This is the real issue, right? Now, on the table, again, please don't build a deck with these, but if you haven't picked up the actual hex nuts and the bolts, and if you guys haven't done your job to pass that around, okay? Pick those things up for a second. Please, someone pick one up. Or everyone pick up a few or share them, right? So, what you've got in your hands right now is relevant to the picture because The hex nut, that is the size where you start to have a non-zero probability of casualty for that aircraft. That means while this aircraft is flying through the air, that hex nut hits it, you have a non-zero, and it's probably about 5 to 10% in that boundary, probability of killing someone, right? I mean, casualties, you're technically correct, but you're going to kill them, right, if that thing actually goes through. The bolt, that lag bolt, statistically, if that lag bolt hits that 747, you're taking it down. It's done. How many people sit on a 747? Anyone? Guesses? Well, I mean, oh, sorry, not have you been on one. How many people are sitting in one on your average day? 400 to 600. It depends on, depends on your configuration. On the low end, you're in the low 300s, right? Plane goes down, that's a pretty bad day for not only them, but a lot of people. Now let's think about the drone industry. The drone industry hits a 747 at the wrong time, right? This is why amusement parks are relevant, right? All of a sudden, and this is in my area of risk and sort of my cynical way of looking at some of these things, right? That's really relevant, right? One person gets it, that can happen across the street coming out here today. 50 grandmas in a bus get it, you've killed an industry, right? We've got to be realistic about these things and how we perceive them as humans, right? I will drive 5 hours to Chicago to avoid, individuals will drive 5 hours to Chicago to avoid a 45-minute flight. I live in Des Moines, not from here. I don't know how far you'd have to drive. Don't do it either way, right? I will do that because as humans, we have this different understanding of risk. We have to be accounting for that as we look at this. We have to be accounting for this as we think about the future of this industry and the future of whether or not we allow it to provide excess innovation or we allow it to provide excess death, right? In some senses of both the industry and individuals. Now, this competing approach is still existent within the FAA in general, and this is one of the things we have to think about as the FAA is building these new rules, is within the FAA you have two competing theories on how you regulate. When the FAA brought in commercial space in the early 90s, you actually brought in a completely different regulatory philosophy. FAA has always on the aircraft side said, we're going to test this thing until we know this thing is never going to crash, right? Rockets say, this thing's going to blow up. We just got to make sure everyone's far enough away, right? Because a new rocket from a new manufacturer will blow up 3 out of 4 times. By the 5th shot at it, right, you're about at 1 in 100, right? But rockets assume it'll blow up. Aircraft assume it'll make it, right? And on the aircraft side, you're like less than 1 in a million that you don't get there. And ironically now, you're 3 times more likely to survive a crash than you were. That's a completely new outcome from 20 years ago. But we got to remember, when you're looking at the problem from this, it's like the 6 and the 9, right? It's like we both see the same thing. They're both seeing the same approach. Drones fit right in the middle. And that's our problem. We've got an unproven vehicle that looks like an aircraft, but we don't want anyone to get hit with it. How do you actually reconcile those two things within the FAA? And we're going to have a very, very interesting time in the coming future, right? Because you have to both protect and prevent are the two competing forces in that FAA. Which one wins out should be both. And the question is, how do we smartly get both? Well, as we identified already, 107's gone through. We have a whole bunch of new stuff that's coming in. But in a whole part, the fundamental top order of it, top line of it, looks the exact same as it was a year ago. And if you listened to me a year ago, I might have been a little more cautious about the direction of these things. And when you look at it, the restrictions haven't really changed much. So this is the eye test chart. Sorry about that. Don't worry about it. Nothing changed from a year ago, and you can always read this in the book anyway, right? The other piece that's the most important, though, was identified some things that haven't changed, right? I'm line of sight. I'm making sure that I'm actually not overflying any individuals. So this is illegal, right? Technically, right? This is illegal, one to many, right? Currently right now, right? This means this, which in my opinion is going to be your history, this is your future of how you make money in drones, which is cluster flying with or without single pilots. This is currently still illegal, right? But where are we going? Right now in agriculture space, right, to use these things effectively within the restrictions without waiver, you're looking at these things that fly for 20 minutes, you have to stitch them for 2 hours. There's technological issues that have to be solved in order to make this profitable. This model is not profitable by any stretch of the imagination, even with free labor that's paying you an internship cost to be there, right? You still aren't going to get this done, right? So we need to actually be making a few changes and be mindful of what the actual real-world application is of this within business. But the issue is, what do these things cost? What does this regulation cost? What are our issues? And right now, as I said last year, if we keep going on the path we're on, if we keep going with a one-to-one relationship, we keep going with line of sight, which you got to remember why these things occurred. Line of sight was originally intended as a distance limiter. We believe sometimes in the public space that line of sight was identified as making sure it's a safety control. It was a distance limiter that had unintended consequences, right? Until we get into what the preamble is and the thinking is behind it, we can sometimes miss and then get stuck with a concept that's going to be in the future very, very unfortunate for us. And so if we aren't careful with why we did it and what it actually meant when we intended it, we can end up on a path where we're basically in a rut forever and we kill the industry, right? This is where the hopeful side comes in. When you look at the list of waiver items, it's like pretty much everything except weight, right? But besides that's, saying weight is waivable would be like saying, well, yeah, you can be a human, but you can also be a dog, right? They have to draw a line on how they're bounding it. I still fundamentally disagree that weight is not your issue. But the beauty is, it seems like the FAA does too, because where we're going appears to be energy. What we mean by that is, I was fortunate enough to be able to opportunity to actually speak at the Advisory Regulatory Committee for Micro UASs. And at there, you had the whole industry coming in. They're saying, okay, what are we going to do about this? And it turns out, there's tons of opinions, right? So if we got 20 people in a room, we've got 35 opinions, right? And that's a good thing at this point in time. One of the things that we're able to actually present, though, was how do we actually start meshing what is coming from the actual commercial space side into the drone side to come up with an actually clear, scalable path forward. And what it turns out was my approach wasn't as crazy as it probably would have seemed to be 2 years ago or even a year ago. And the fact is, it seems like the majority of the room was sort of in agreement this is how it's going. The question is, how do we do that, right? And what we mean by that is a quick primer on what this actually means and what it means as far as what would have to occur. What we presented was, how do you actually do this, right? How do you actually move to energy? Right now we say, okay, if it's above this weight, we're good in these places. Well, that leaves a lot of things done. That does not help you with a 45-pound weight flying across from the front to back of your car. What essentially you have to do looks a little more mathematical, but essentially what we're doing is we're saying, what's the characteristics of this vehicle? How big is it? How much energy can that vehicle transmit? And if it fails, how far can it get? Those are your three fundamentals of, and those are, I'm looking at you, I'm trying not to make this complicated. It's pretty basic, right? What do you got? What can it do? Where can it go, right? Pretty fundamentally easy, and fundamentally easy mathematically as well, to a certain extent. Next piece is, once we know what this thing can do, what we have to add is the issue of, where are you? Sheltering, structures, right? How protected are you relative to this energy transmission, right? That piece is where we're actually going to see some of our biggest answers. Because right now, within the regulation, as identified, there's a few pieces that we really don't know what they mean, right? What's overflight mean? Does overflight mean I can look straight up and the thing is right there? Why doesn't it include stuff that's over there that's actually coming at me? Which is overflight? Right now, we've sort of quasi-punted on it, right? We don't have an answer yet. When we move to energy and we start moving to shelter, we're moving to these sorts of items, these are one of the only ways you can actually solve that. Overflight right now is completely ambiguous to the point where it isn't tied to safety and risk. That's getting solved, which is, from my standpoint, very, very exciting, and I think for an industry, very, 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 very good. We're looking at sheltering, for example, right? If I'm in the air, these three individuals, assuming they're equivalent individuals, are equally at risk. If I now put them under different shelters, the issue is sheltering, right? What is sheltering? We say under shelter, right? Not all shelters are created equal, right? One shelter can actually be a benefit to you, one cannot. When you start looking at sheltering, sheltering is a definable quality. Sheltering is something we've been doing since the 1960s in the rocket business. This isn't new, right? And within sheltering, we can say under specific shelters, this is what your risk is. And what's interesting is that risk, while we're hopefully going to be solving some of these problems in the coming summer, right? The issue is not all risks are equal. Under certain shelters, while I can be safe, and some I might be more at risk. If I'm sitting under a greenhouse, for example, right? In that greenhouse, that thing breaks. I've got glass everywhere. That one drone, which could have only hit one of me in public, can now hit 5 to 10 of me. We have to be conscious about what type of shelter I'm under, right? And while this all seems like it's it can get absolutely complicated, if we're going to fly these things safely, there's no way around that, right? At the end of the day, if we want true innovation, we have to get better about how we characterize what this risk is, right? I'll speed up. Don't worry. I see one who says we're in the weeds. So what we actually do from there is based on our actual sheltering. We now say, okay, under this sheltering, this is where you blow your risk requirement. What that means is I can come up within cities even. I can come up with maps of here you fly. And what that means in the big scheme of things is I can now actually come up with aeronautical charts for drones. Those aeronautical charts for drones, as you know, these are actually computer operated to a large extent. You can actually load the geofence straight into them. You can actually in the future have this thing fly in it just like a regulator on a moped, how you can't go over like 2 miles an hour, whatever it is, right? Unless you take that thing out, right? Now all of a sudden we can actually start making sure that these things are not in areas where they're actually causing that risk. The opportunity there is absolutely massively huge for the industry, right? That becomes incredibly fun, incredibly interesting. It seems like that's where we're actually wanting to go. And that part is exciting because what it means is if I can say, this is the boundary outside which you hurt someone, if I'm inside that boundary where the risk is acceptable, I'm deregulating. I can fly wherever I want because the acceptable risk that society is willing to accept from this aircraft, now it's zero. Do what you want, which becomes really, really, really fun, right? And I'm actually sort of hopeful that's where we're going on this thing. The other area that we can actually do to start opening up airspace, which is also being looked at as design solutions. Remember our magic number is 11, right? Well, if we're saying at 11 is our boundary, if we can actually create a drone that actually does not produce 11 pounds of energy towards you under any situation, it's safe. Go where you want, right? Why can't we have a balloon, right? If you're under 11, you're safe, right? At the end of the day, though, when we're looking at what could happen, as an industry, as individuals in that industry, as purchasers of these vehicles, as individuals who are employing these vehicles, the question is, do you poke the bear, right? I mean, that's always a question. What can you expect the FAA to do, right? Everything about our governance, everything about our laws is designed to say if you want the system to work, it works really, really well. If you want it to break, you break it, right? And it will break. This is no different, right? I don't know anyone that mows their lawn without a ducted blade. Yet we're sitting there fighting about whether or not we duct blades, right? You put that drone in fully ducted beach ball and fly that thing around so you're never going to transmit 11 foot-pounds. Well, there's no argument for regulating it. Do we want it flying or not, right? And this is with all these things that we see, and this is big picture, and not I'm sure my political beliefs are sometimes loggerheads to some of my recommendations, how we look at things, right? Which I'm sure is probably unusual to most people who know me well. But the issue is, if we're looking at this, we have to help the system and help the outcome we want, right? If we're looking at this as the FAA is going to allow me to do this, versus the FAA is here to facilitate my actual business activity. Those are very, very two different strategies we need to take. We need to be really realistic as individuals within the industry, as leaders in the industry, especially for one of the first ones, as to which one we're going to actually provide, which relationship we're going to facilitate. And at the end of the day, what are we actually really expecting in those trade-offs? What are we really expecting? What do you actually want out of this thing, right? What do we really want? If you want to fly, the issue should not be, hey, Mom, I really, really need that cookie. Give me that cookie, give me that cookie, give me that cookie. It's like, eat your dinner first, right? Come on, let's be realistic, right? What do you want the FAA to fundamentally do? And that's what we're really sort of needing to get out of this thing as industry leaders is what can we do to actually help facilitate the outcomes we want, which are, if I've done all the work of ensuring I'm going to be under 11 foot-pounds within that public, what can I do to make sure we get to that outcome? A lot of this is going to be industry-driven. Government will not be your answer to you. If you want to actually make the change, we've got to start making changes in industry, knowing how the government's going to look at it. So we made it through almost the whole phone test, so thank you very much. I appreciate that. Good Lord. And I don't mean to resort to shaming sometimes, sorry. Any questions or any issues? Or
I had a question. When you were talking about the origin of the on-line of sight restriction, you said it wasn't safety, but it was a distance limiter.
Not necessarily, not the issue of beyond line of sight, the issue of requiring the line of sight. The original thinking, yes.
Line of sight was a limiter, but distance limiting doesn't seem to be an end, it seems to be a means to something else, so what was the thought in limiting distance?
My understanding of what the thought in limiting distance was, if all of a sudden I'm saying you have to see the thing, right? What it means is it can't get far enough away from you, so you're going to actually be below the different airspaces where we have a whole lot of activity. That was the logic. Was it accurate? Heck, I don't know, right? Was that person's opinion of recounting what those early discussions were? I mean, was that fair? Great example, right? The rocket business. In the rocket business, it was always historically, they just changed it. You're allowed 30 casualties per million per flight, right? And everyone's like, oh, well, how do we actually get to that? And there's all this big old discussions about, well, it's this and this, and we can tie this to this and this and this. It was basically a consultant and the general having a discussion after a meeting, and they said, how many can we kill a year and not have an issue? Well, it's this, we'll divide these numbers, and bam, 30 million, right? So sometimes the reality of what we actually get to, ironically, in any of these situations isn't always as thoughtful. It doesn't mean the outcome isn't good, right? It doesn't mean that right now, having one-to-one, given where the industry is, isn't a good solution. It just means we got to be careful as to how we got there and not read too much into what that could mean. I personally believe that was actually originally intended, as I understand it, to be an actual issue of distance limiting, which is going to be essentially keep you out of higher traffic airspace, higher traffic lanes and things. Maybe that's not even right. So keep in mind, none of this is an official statement, right? But that was my understanding of what the logic was. Our job is to figure out how do we actually make sure we understand what it could have been and understand what it actually truly says now and how we provide industry-driven solutions that are going to get us to where we need to be, which in my opinion still becomes energy-based exclusion. Did that answer your question? I'm sorry, not to be a complete circle in some pieces. Any other questions, issues, concerns? Crazy, nuts, all right? Sounds good. If you do have questions, again, my contact details are up here, and you know, as you're going, if you're needing help or anything else sort of clicks tomorrow, we're happy to help. And again, one of our pieces is figuring out how do we navigate that 333 section, and how do we actually provide the meat. With all government documents, right, you need 300 pages of unexplainable stuff with a few trends you can interpret in red, yellow, green. We help you get to red, yellow, green. So, thank you very much.
Thank you, Chris and Thad. We will begin again at 10 a.m. and we look forward to Jamie's presentation then.